Hi there, I'm back, because I'm pissed, actually. And you know, the summer of legalization, I'm not going to have wasted all that tour for nothing. We're going to make that the winter of our discontent. And actually, I've looked at this decision. This is what the Ontario Court of Appeal decision is bad, terrible, all over. The government tonight is drinking champagne and celebrating. They probably called strippers, and they're having a great old time. They got everything they wanted on a silver platter from the Ontario Court of Appeal, including stuff that's not even lawful. So I'm appealing it to the Supreme Court. So Allison, Murden, any of the people who were the litigants about the MMR is still unconstitutional. The court exceeded its authority like way a lot, and I want to appeal it to the Supreme Court. Get in touch with me because I will finance that appeal to the Supreme Court. First of all, the Ontario Court of Appeal originally suspended the possession law, and they reiterated it here, so it wasn't like we made it up, it was a fluke, right? The possession law on marijuana was suspended from the Controlled Drugs and Substances Act. A declaration of invalidity was given. That means it's no longer around, cannot be brought back, can't be resurrected by a court, that's for sure. And that is the primary grounds to appeal it to the Supreme Court, is that a court can't be the remedy of a declaration of invalidity. When the declaration of invalidity, the court says there's no law because the law is unconstitutional. Well, the law doesn't get brought back when the court at a much later date decides it can tinker with some regulations, which it's also not entitled to do, and therefore bring prohibition back. The original order was that the government, through Parliament, had to pass a new legal access law through Parliament, or at least it had to be a constitutionally valid regulations. The MMAR is declared to be right now unconstitutional. So the government did not, in either case, possibly satisfy the original court's declaration of invalidity. So the law doesn't exist and cannot be brought back. And I believe that if an Ontario Court of Appeal says that the law is invalid and that Parliament has to come back with a new law, then that's what we have to have. And the fact that the Ontario Court of Appeal itself has been the remedy. Remember, courts don't write new laws. Courts strike down bad laws that don't offer the guarantee under the Charter of Rights. And I'm going to point out how what the court has done in the Ontario Court of Appeal doesn't do any of that. So it should get addressed by Parliament, but didn't. The court resolved its own declaration of invalidity. That's not possible, and that has to be appealed to the Supreme Court. Okay, here's the other thing is, the whole reason we're there is because the possession law was declared unconstitutional as a threat to people's security of the person part of the Charter. Okay, so 26 months of legal possession has passed, and thousands of Canadians have been convicted of a law that didn't exist. And yet the court admits this, but offers no remedy. Like, there's tens of thousands of people who've been falsely convicted of possession and personal cultivation when there was no personal possession law. That has to be addressed. That, the Ontario Court of Appeal didn't even begin to deal with that. Now that they've made it so that marijuana was really legal for 26 months, but the government, as always, refused to go along, refused to acknowledge, refused to uphold their obligations to obey the law. Inexplicably, they don't get punished. You and I get punished, the people who are already made victims of a law that didn't exist. So my trial in Regina on October 16th, if we can get to go ahead on that date, will focus on the fact that I was legally allowed to smoke marijuana, according to the Ontario Court of Appeal, when I broke the law in Regina, or broke the old law in Regina, on July 11th. Well, we're going to be there to say, not only am I not guilty, but what remedy constitutionally is being offered to all the tens of thousands of Canadians who've been convicted since July 31st, 2001. They were falsely convicted, wrongfully convicted, convicted of a law that didn't exist, that the Crown would have at the time known that, and yet continued to prosecute. Are those prosecutions, those convictions going to be held as valid after the Ontario Court of Appeal now has reiterated there was no marijuana possession law for 26 months? That's scandalous, and that's why we have to appeal it to the Supreme Court also, so we can get the Supreme Court to make a declaration that there was no marijuana law that affects all Canadians. Because here's the thing. The government's not appealing this decision. They can't say, oh, well, the marijuana law was just suspended in one province, because I'm assuring you that the current regime proposed by the Ontario Court of Appeal, like the new medical marijuana access regulations, the Crown, the government is going to accept that. And that is going to be applicable to all the provinces, right? So if the resolution offered by this Ontario Court of Appeal is going to be applied to all provinces, and it will be, then they can't say that the medical marijuana possession law, which was struck down by the same court in the same verdict, in the same decision rather, is is applicable only to provinces. It was such that all across Canada there was no marijuana possession law, and the Crown is going to have to inherently accept that if they accept the rest of today's verdict, and they sure are. They're celebrating like crazy right now in Ottawa, getting everything they wanted on a silver platter. So there was no medical marijuana law. We have to fight to have up to 30,000, 40,000 convictions overturned, and I believe we have a good argument. We're going to start making that argument in my Regina case on October 16th. Okay, here's another thing that's wrong. The court itself, the Ontario Court, rewrote the medical marijuana laws to correct. They found it unconstitutional. Today's decision actually says the medical marijuana access regulations are unconstitutional because they violate the security of the person. But instead of saying that and leaving it like that and declaring the medical marijuana law of regulations of no force and effect, saying the possession law has no force and effect, they literally bring back prohibition and they bring back the medical marijuana access regulation with some minor tinkering, of which the court is not allowed to do. The court cannot actually rewrite legislation and rewrite regulations. They can only order the government to do so and to make appropriate remedies to the Charter. The court itself has no right to do that. And so again, the Ontario Court of Appeal has exceeded its lawful authority, and I believe will be seen as such by the Supreme Court. So Alison Murden, contact me. I want to help go to the Supreme Court. We can do this. The court cannot make a declaration of invalidity and later say the declaration is dead, just because they think so. They ordered the government to change it. The declaration has been suspended, gone, finished. It cannot be just brought back like some seance bringing back old legislation. That's not how it happens. This would be a first in the history of Canada that a court has ever resurrected a dead law after being off the books for 26 months, certainly by their own decision. Okay, and the funny thing is the medical marijuana people don't get anything from this. Yes, marijuana possession law was eliminated and is being held as such for 26 months. But the medical marijuana people law, the tinkering only means you only need to get one specialist instead of two. But here's the thing. The medical marijuana access regulations were tossed out because they violated the security of the person of the individual Canadian who would have to go to the black market, criminals, and get their pot. That was ruled. That's not safe. That's not security of the person. Well, how about this? The doctors refused to cooperate. So even getting one specialist may put someone in peril. Doctors have been instructed by the Canadian Medical Association not to cooperate. Many doctors won't cooperate. Many doctors have no grounding in marijuana. So the security of the person, of anybody who needs medical marijuana, is threatened by the fact that doctors have been ordered not to participate, have themselves indicated they won't participate. They have no legal regimen by which to follow any kind of like prescription advice on marijuana because they get no instruction from the government. And the government is no longer obligated to sell marijuana, so that'll end probably in the next few days. The court ruled that since they expanded the medical marijuana access regulation to require only one specialist, notwithstanding that doctors refuse to cooperate. And then they made it so that people who grow marijuana can actually charge you to grow it now, which they couldn't before, and that you can designate anybody, including a person who's already growing for someone else, to grow your own marijuana. They have said now there's a legal access. So therefore, with the legal access, the government doesn't need to provide marijuana. And they can, not only do they get the prohibition back, they don't have to sell marijuana. Every single thing the government wanted, they got from the Ontario Court of Appeal, and I would wager completely unlawfully. And the security of the person is still threatened, and the government pot is over. There is no requirement for the government to grow pot or provide pot. The government can even further add regulations to the medical marijuana access regulations to make it more difficult, more onerous. They can make changes. The Ontario Court of Appeal decision, as left like it is, gives the government incredible latitude, and it will be nothing but frustration. In 6 months, not a single medical marijuana person will tell you it's easier to get pot, that it's more convenient to get pot, that it's cheaper to get pot. In no way will anything for anybody who needs medical marijuana improve. The price is still going to be expensive. Access is still going to be difficult. Compassion clubs actually can be licensed by the government, but under severe regulations. And no way will you be able to have brownies and tinctures and all these things at compassion clubs that they have now, where they currently have sort of like a sort of a suspended legal status at all these compassion clubs. But the government can very much regulate it so that there's just one kind of pot available for those companies. Because remember, the government's been insincere all along. They never told the public that marijuana possession was legal, ever did they agree with it. Now the courts have said it was legal for 26 months. You never heard it from the government. The government did not want to sell pot. They don't want to provide pot. They don't even really want to make it legal, except the courts in the past have ordered them to accept some degree of legalization of pot. The government is totally indifferent, callously cruel, and they are totally opposed to their own medical marijuana program, so we can expect no help from them. So we have to mobilize, contact the committee, the House Commons Committee that was struck to bring in the new reform bill, which, as we know, is terrible news, with its 14-year, maximums, a proposal for mandatory minimums, no home cultivation, nothing in there at all for medical marijuana. It's a complete rout and a disaster. So any of the litigants who were represented by Bernstein and Young, get in touch with me. I want to go to the Supreme Court. I don't believe that this is an acceptable decision, and we are going to fight, fight, fight. And we're going to fight with Parliament. We're going to fight when the courts continue. We're going to fight on the street. We're going to keep those compassion clubs open and serving whatever they need for all their medical marijuana people. And all the new Smoke Easies, Hippie Cafe, Hot Box Cafe, we have to protect these places so that people can continue